With the recent nomination and confirmation hearing for Judge Ketanji Brown Jackson, a once mundane process has continued to snowball into a platform for grandstanding, demagoguery, and virtue signaling from both sides. A lifetime appointment to one of the nation's most prestigious branches of government should be taken seriously. But has the continued growth of partisanship tainted both the selection of nominees and the confirmation process? Conservatives favor an originalism view of the Constitution, an as-is approach. Liberals prefer a living Constitution demanding modern challenges require modern solutions. There are pros and cons for both viewpoints. But was there an original intent for how the Constitution should be interpreted? Well, kind of. Not directly stated in the document itself, but the procedure in which amendments are to be adopted is a recognition that the Constitution is not ironclad and open for revision. Thomas Jefferson was a vocal advocate of this. He recommended a new Constitution be adopted and laws should expire every 19 years as to not shackle future generations to the desires of those of the past. A quote within his monument says, "I am not an advocate for frequent changes in law or constitutions, but laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths discovered, and manners and opinions change with a change of circumstances, institutions must advance, also to keep pace with the times." He wasn't the only founding father who publicized this either. Couple their mindset with the provisions of amendments, and it's safe to say the Constitution is subject to change, and even encouraged to an extent. But does that mean the Supreme Court can legislate from the bench? Absolutely not. Changes to the Constitution, and the living status, if you will, resides in the responsibility of the legislative branch. The people, through our representatives, make changes based on the majority of the nation. Laws should be developed by the aspirations of the people, and the liberty of the individual, despite majority consent, should always be protected. That's where the Supreme Court comes in. They shouldn't deviate from the Constitution to include their amendments, and to ensure the protection of freedoms to the people, and to restrict government overreach when presented. The Supreme Court is tasked with a difficult job. They have to be steadfast and void of emotional attachment. And yet, despite this impartial, secular, and cumbersome burden, the Supreme Court was basically just a byline in the Constitution, and its creation was tasked to the legislative branch, which, as you can imagine, has been a catalyst for continued contention of how the Supreme Court should respond, even to this day. Even things as simple as the number of Supreme Court justices has fluctuated. It's been argued, and the practice of packing the court isn't technically unconstitutional. Nor is there a time limit or a period requirement to nominate and confirm new Supreme Court justices. Those 2 points have recently inflamed partisanship, with Democrats threatening to add new justices to overtake the current conservative bloc majority, and the bald-faced hypocrisy of the right when blocking Merrick Garland's nomination by Democratic President Barack Obama a full 8 months before the 2016 election. And then turning around and fast-tracking Republican President Donald Trump's nominee, Amy Coney Barrett, barely a month before the 2020 election. It's this political chess match, this lack of integrity and manipulation by both parties that have led to this increased partisanship when selecting new Supreme Court justices. So where did all these confirmation hearings go wrong? Well, Ted Cruz's scathing rebuke of SCOTUS during the 60s and 70s kind of pinpoints where the highest court's rulings became more noticeable. It was the Warren and Burger courts that presided over these tumultuous times. Even though Chief Justices Earl Warren and Warren Burger were nominated by conservative Republican presidents, Eisenhower and Nixon respectively, they became known to have a liberal slant. And that can be argued. But it's best to recognize the significant changes our nation was experiencing then. And many of those rulings did recognize individual freedom, expand equality, and reduce government involvement in regards to private citizens. So it were these landmark rulings of the 60s and 70s that brought SCOTUS into the limelight of politics and prompted the partisanship in selecting justices. Before that, SCOTUS only made the news with terrible decisions like Plessy v. Ferguson, and confirmation hearings were bland. And though there were scattered rejections throughout history, many nominees were typically moderate and approved in majority by both sides. The departure of this humdrum confirmation process happened with the nomination of Robert Bork in 1987. It was brash opposition by Democrats, even before confirmation hearings, that set an ugly precedent. They exaggerated Bork's ideology and catastrophized his influence if approved to associate justice. Though his personal views did raise questions about his judicial philosophy, his record actually mirrored that of Thurgood Marshall, a conservative appointed justice who voted with a liberal bloc, especially concerning those landmark decisions. This smear campaign became known as borking, and Robert Bork got borked, and his nomination voted down. This entrenched solid phalanx of opposition quickly reared its ugly head again 4 years later, with Clarence Thomas's confirmation hearing. This drug out and targeted his personal character, namely sexual harassment allegations, instead of concentrating on jurisprudence and his historical rulings. Justice Thomas was ultimately approved, and we would never have any controversy from him or his wife Ginny ever again. Luckily, there was a decade of peace, so to speak, with the nominations and confirmation of Justices Ruth Bader Ginsburg and Stephen Breyer being approved with little opposition. Even the nomination of Chief Justice John Roberts was met with bipartisan approval, though every justice since has been voted for mostly along party lines, with less and less bipartisan support, with Amy Coney Barrett being the first justice since 1870 to be confirmed without a single vote from the Senate minority party. This ever-increasing partisanship was on full display with Ketanji Brown Jackson's recent confirmation hearing, and instead of dissecting her judicial philosophy, it was a rally cry of virtue signaling toward current social issues and selective case hearing in effort for gotcha politics. And it seemed more of an audition for Trump's next VP by Senators Cruz and Hawley, with their incendiary rhetoric and emotional exploitation in efforts to vilify the left as a whole, instead of an honest attempt at analyzing her potential judgments. And it's this whataboutism that the right uses to defend their treatment towards Jackson. Ketanji Brown Jackson will be confirmed, even if she follows in Barrett's shadow of receiving zero Senate minority support. And though race or sex shouldn't be the defining metric in any determination, we should all be proud, regardless of ideological differences, that women of color are ascending to positions of power, and those opportunities are now attainable to them. It's true maturation of our country. But despite this smear attempt, or borking, by some of the members of the Judiciary Committee, and misplaced affirmative action comparisons, Ketanji Brown Jackson is extremely qualified. And her confirmation and ultimate appointment does not disrupt the current conservative majority in the Supreme Court. So, is there anything that can be done to dampen this continued standoff? I'm glad you asked, because Yes, again, Congress was tasked with developing the foundation of the Supreme Court, meaning they inherited the responsibility to make changes. First off, set actual requirements for potential justice nominees. There are requirements indicated in the Constitution for all of our elected officials, including the president, yet nothing for SCOTUS. Currently, there is no requirement for a law degree, for the age, or even nationality. These open requirements aren't necessarily a bad thing, but it would help in the vetting process and lead to more experienced justices. And it could stifle hypocritical actions like those of Mitch McConnell. If there are parameters in place that dictate a time frame for nomination and confirmation, it would force the Senate's hand to vote.
Do it! Just do it!
And avoid partisan roadblocks. And determine a criteria for a consistent number of justices, whether it be a correlation with U.S. population, states, districts, etc., but put determining factors on how or if an increase in justices are required, making packing the court threats moot. And term limits should also be implemented.
Thank you!
And this goes for Congress and the Senate as well. Setting term limits does two things. It allows justices to stay current and, like Jefferson said, keep pace with the times. There is no perfect consolidation of justices that would appease to the masses. And despite personal ideologies, SCOTUS should view every single case apolitically. Laws and institutions must go hand in hand with the progress of the human mind and mirror our enlightenment. But SCOTUS, and even us, should conserve the notion of our Constitution and embrace the desires set by the Declaration of Independence, in which we are created equal, that individual liberties are paramount to freedom overall, and the protection of our unalienable rights, no matter our differences.